and gentlemen, boys and girls, we're here today, a little how-to guide to all you brave souls that want to venture into evicting. When you say evicting is a broad term, kind of has a connotation of its own, kind of like that. Really, it's more than that. There are times when we need to have a more of an understanding attitude and working with a tenant in order to maybe get some of your money that they owe you, or straighten out the problems that they're having, and keep them. If they're otherwise a good tenant, booting them out is not always the best answer, and that's what we're after, is the best answer that we can do for the owner. So today's session is going to be basically how we go about eviction, whether it's a conditional order, meaning that they can stay if they meet the conditions, or an unconditional order, meaning that they have to be out on a particular date and time. So most people think it's pretty easy, just put the bugger out and it's over. Well, in the old days it was like that. You know, I remember in the 70s. If you're following that, you'll know that I'm going to be 70 this year. And in the old days, I used to be able to get behind them in the house and holler and scream and push them out the door. I remember being young and strong and picking up one end of the couch and lifting the other end and then taking it through the door and throwing it down the steps to the street and scaring the hell out of them so that they got all their stuff out of there. You can't do that anymore. That's not allowed. We have a process, and this is a process that we're talking about today. Not to use this clicker thing. And I'm going to apologize too for my voice. I've been suffering with a cold all week and break into a coughing fit. I'm not dying. I'll be okay. At least I don't think I'm dying. So Section 21 of the Residential Tenancy Act is what we follow. This is our main guide as to what reasons that we can evict for. The main one is 21A, which is the non-payment of rent. The rent's got to be paid on time and in full, not if the sky's blue, or if they have the money, or the dog's not sick, or somebody died out in Ontario and they have to go. That doesn't matter on anything. Interfering with the rights of the landlord. Those are that's items that including noise and causing problems with neighbors, maybe downstairs or upstairs, or in other suites, up and down suites, or apartment buildings, or even in a house where they're having parties and the neighbors next door are upset. And even doing things that cause complaints to the landlord, and therefore they're interfering with the landlord. Illegal acts or businesses, and this includes, often I see items like somebody's running a garage out of their a repair garage out of the garage on the unit, or that sort of thing where there's traffic coming and maybe parking in the neighborhood. And I've had a couple of times where ladies of the night were renting, and so the customers would come and they didn't want to park right at that house. They parked in the neighbor's garage or whatever, and caused a problem. And that's how all that was discovered. So it doesn't necessarily mean that they're selling cocaine or something. Could be most anything. Endangering persons or property. That's certainly doing things that could endanger people. I've had a couple of times now. I've had where tenants lit a fire in the front room, made a camping, some rocks and lit a fire. First time was on a brand new hardwood floor, like they were the first tenants. And they had a big party and roasted wieners in the front room. It doesn't have to be that bad. But doing things that cause flooding or whatever can damage, other people, cause problems for other people. Walking around with a gun, did that more than once. Significant damages, that speaks for itself. Breaking windows. I had one where the tenant texted the landlord and said, I got mad and I threw a hammer through the window. Sorry. Well, it didn't last too long. Not keep the place in a reasonably clean condition. This is quite often, and people say, well, what does that mean? And does it have to be sparkling clean where you can eat off the floor? Or is it such a mess that you don't want to walk on the floor? And it's what a reasonable person would do. When I first took my first law course, they had the professor came in one day and he had a T-shirt on and it says, "I am a reasonable person," written on it. And that was the lesson for the day. And he says it's what a normal regular. You took 100 people, what the majority would say is a reasonable thing, and that's what a reasonable person would do. So a reasonable person wouldn't want to. Wouldn't keep their place in such a mess that you can't walk in it. And certainly I've seen many of those where there's a path through. Literally a path through. You couldn't walk from one place, one side to the other, and there's stuff piled up. And the kitchen, if you could pass through it, it's a wonderful thing. And that, hoarding, many hoarding situations. That's not an acceptable thing. If you have 4 or 5 children, the place isn't going to be sparkling clean all the time anyway. Children create a mess. It's not that you have a dirty place; it's just been decorated by small children. So these are all things. Some of them are easier to discern than others, but they all can add up. And if you look through this, at the weight in the when you're going to court, the weight decreases as it goes to the bottom, except for the bottom one, which is overholding. That's on a fixed term relationship. When that fixed term lease is over, Section 15 of the Act says that the tenant is expected to leave unless prior arrangements are made. So you don't even have to give them notice according to the Act. The right thing to do is give them notice saying I'm not going to renew, so they have a chance to go and find another place. And if they don't, then you take that and that's the closest thing to a slam dunk that you can get. There's no such thing as a slam dunk that you have everything in place that you're going to win 100%. I mean, there's all kinds of things that can occur at a hearing, but overholding is the closest thing we'll get to a slam dunk. So that's the reasons that we would evict. Combination is good. Non-payment of rent, I've had as much as $50,000 owing. That's way too high. You should never have gotten that high. A month, 2 months. Sometimes by the time you get things straightened out, it's 3 months. But people tend to, whoops, wrong way. Want to give the tenants a chance to redeem themselves, and find a way of paying or fixing. Give them more and more chance, and that just doesn't work. It works against you, and you have your mortgage to pay every month, and you.
Does it has any certain amount or certain months of rent can be due to file them against?
you're asking whether if there's a limit or a beginning amount that you could sue with, for. No, any amount is $1. I've actually gotten an eviction on a $2 difference. There's a lot more to it than that, but that was the basics. So any amount, certainly if you get into 2 months, that's actually the maximum that, in my mind, that you should allow. I mean, everybody's different and got different situations, and sometimes those things sneak up on you. You might have 30 or 40 or 50 units, and you're hustling to try and keep on top of everything, but things slip. And so you move as quickly as you can. So yeah, there's no minimum amount, certainly no maximum amount.
If it is a fixed term lease, still we need to give a notice that we are not renewing them, or it's not mandatory?
On a fixed term lease, whether you give a notice or not, yes, you don't have to give a notice. Section 15 just says that they're expected to leave. But it's the right thing to do would be to give them notice to say that you're not going to renew the lease at the end of the term, just so they have an idea. Some tenants, I've had that lots of times over the years, as they just disappear at the end of the fixed term because that's all as long as they wanted to stay there, which was fit my bill exactly. So what is the process? Here we go. We got to gather the documents. We got to apply to the court of our choice. We'll go through each one of these separately coming up. Assemble the notice of hearing packages. I should say in your package there's a USB that has this on it, so you don't have to worry about. You can take all the pictures you want. And there's other paraphernalia there for you. We'll go over some of that. Anyway, serve the notice of hearing and complete the declaration afterwards so that the court knows that you've served it. The tenant's got it. And attend the hearing, of course. If you don't attend the hearing, it's going to go against you because you're not there to speak for yourself. Court order, you end up with a court order and judgment, and then you file the affidavit of service after you've served them the court order. So let's go through this process now. The right direction here. Here we go. So the documents that you need to have, this is a minimum, and not everybody has all of these documents. There's people that still have done things on a handshake, or they feel that they made a lease agreement 15 years ago. That person's been there 15 years, and so that lease is no longer good. It is. It's still good. It's just not a fixed term anymore. It's called periodic, or month to month. And excuse me. Oh Lordy. Anyway, whatever you have for a lease agreement, even if it's written on a napkin, that's fine. I've had some funny things come through the door. Any kind of notices, notes, letters, that sort of thing. So if you give a 14-day notice or a 24-hour notice for somebody that's caused done something in anger and hit somebody or whatever. Any emails, text messages that pertain to what we're talking about. So if it's not non-payment of rent, then the email saying, please pay me the rent, or when's the rent going to be paid? And you get the answer back next week, and just fail to tell you what year. And if you get anything that's kind of out there, we've had where there's a concern about mold, it seemed to be it comes in waves. You get a whole bunch that the tenants are concerned that got mold. You need to have expert opinions that somebody comes in and takes a look at whether it's Alberta Health or if it's environmental health, or if somebody hired especially that can do mold testing or atmospheric testing, any of that kind of stuff. So anything you can get that's, if there's a flood and they were flushing ladies' napkins down the drain, and so you need from the plumber saying that they pulled out. This is what they pulled out, and so now you can charge that to the tenant, unless it's all guys in there, and then you gotta ask them what they're doing. Or maybe you don't want to know. Tenant ledger, that's very important. The judge likes to know that when the rent was paid. The court sees late payment equally as bad as non-payment. So if you have a history of them paying, and then usually it goes in, they're 3 days late, and then they're 5 days late, and then it's a week late, and then it might be good for that, a week late for a little while, and then it's 2 weeks late, and then the next thing you know, they're paying you at the end of the month instead of the beginning, and that's just all wrong. Any neighbors, testimonials, that sort of thing, where they maybe text you or email you and say, they've been from 11 o'clock till 4 o'clock in the morning, they've been partying over there, and I can't sleep and I gotta go to work. Excuse me, what? Oh, I'm still alive. Any pictures, audios, that sort of thing, it's getting more and more nowadays. We're getting, especially pictures, audios, videos, especially of messes. I've seen yards, tires piled up, and engine parts, and piles of boards, and God knows what they're collecting, and it's in your yard, and of course your neighbors aren't very happy. Dog logs, that's especially in the spring when the snow melts, and instead of seeing grass, it's all black from dog logs. I had that. I had one guy promise me he was for sure. He even gave me his new address that he was going to come and get those logs, and he didn't do it. So I hired a couple of young fellows, and we made, I think it was 20-some garbage bags full. I mean, can't put too much in a bag because it's heavy. And I took it all over to his new place and left it on his doorstep. I soon got a phone call. But anyway, all those kind of things you need to help you convince the judge that you need to have a decision in your favor. Now you got a choice of courts to apply to. We used RTDRS, Residential Tenancy Dispute Resolution Service. It only deals with the RTA, it only deals with the RTA, Residential Tenancy Act. And it also deals with the Mobile Home Act. That's just a few years ago that they added to it. We don't get a lot of that. That's mostly for if somebody is not paying their mobile home fees or causing a problem in the mobile home area. So it was created back in 2007 to streamline the process, reduce the backlogs. At that time, it was in the provincial court, provincial and King's Bench. It was, you came 3 months to get a hearing date, and so it was to reduce all that. And its orders is legally binding as the provincial court order. It's the least expensive method. They kept the costs down on purpose because they wanted it to be a cheaper place for both landlords and tenants. As we all know, that not all landlords are golden either. And some tenants need to have that, ability too. And you can apply online, that's a gift from COVID. You can apply online, and the hearings are by telephone conference. I love them. When my grandkids are at home, I can do the hearings from home and nice and quiet. Provincial court is another option. It's a higher court. Oh, excuse me. Getting worse as I go here. And you can apply online with that one as well. And then there's the Court of King's Bench, which is Alberta's highest court. And that's where all orders that we get from the RTDRS are filed, and that become a legal document at that point. That can be served and enforced by a bailiff. Here's some of the things that go on in a unit, kind of like that. We're going to give help. So, you've done all that. You got to apply, and you apply to the court of your choice. As I say, we use the RTDRS. You get an application. In that application, we include the evidence, and it needs to have a focus, flow, and organization. If you're going to be successful at the hearing, you need to have the end game, what you want. You need to understand the Residential Tenancy Act, especially Section 21, so that you're, you're asking for the right thing. You're not going off on a tangent that's got nothing to do with the Residential Tenancy Act, emotional things. You're evicting for a reason, non-payment being the most common. And you need to have a method, and most people fail, a method to quickly find any particular page. So if you want to show that after your presentation that the hearing officer gives you a question, and you say, well, I got that, and you can exact which page that is on, and you'll be able to get to it quickly. And it helps with shows that you're organized, and that you're not wasting any of the time of the court. Each notice of hearing, the package has got to come with comes with a cover sheet. Now this comes from after you've sent in your application. You get back a notice. My goodness. You get back a cover sheet that shows the date and time, and it's got I think I got one maybe in the next page. Yes, cover sheet and a package provided by the RTDRS that has for 4 or 5 pages that shows the tenant what rights they have and how the flow is and what how they can answer any questions that they might have. And of course you include all the information. You start with that part, and then the next is the application that you've sent it in, but the RTDRS sends it back in a different format, and you include that, and then all your evidence comes in after that. So and you need one package for each person listed on the here we go. Each person is on a lease. So this is what happens when renters buy a house. So there's a copy of the notice of telephone hearing. That's the cover page I'm talking about. Gives the date and the time, and that particular one's Wednesday the 10th April at 10 o'clock in the morning. And it gives you different things. If you want a number for them to, for the court to phone you, that particular one, it tells you where to find it. And it says at the bottom that if you don't show up, it can be something against you. So now you need to serve this package. You've got it together, you need to serve it, hand deliver it is preferred, get it right in their hand, and then you have if you can't, then after several attempts, you're required, you're still required to attempt several times. And there's no number in the lease saying it has to be 2 or 5 or 12 or anything like that. It's what seems reasonable. And nowadays we're getting hearings much faster. It used to be 3 weeks was a good time. Now we're getting 8 to 10 days after application, which is wonderful. But it tightens up this space that we have to serve, and so that results in less attempts before you can put it to a door. If they're avoiding you, or they're just not home, you can't find the time to catch them at home, then you can, after several attempts, you can post it to the door they're most likely to use. That's often the back door, or when you come in from the garage or whatever. Or in an apartment, of course, you only got one door. So that the attempts have to be on different days, at different times, and there's you get a sheet, a declaration sheet that has all the different methods. So if you go there one time and somebody over 18 that lives there answers the door and says, well, they're not home right now, but I live here, then you can serve it to them. You just need their name, and there's a portion there, you fill that in. So you can, if you just follow that, if you read that before you start off, then you have an idea what you're allowed to do and what you can't. And they also give you a sheet on how to serve. You can get that off their website, and it comes with the when they send you the package. You post it to the entrance door after several attempts, and you can email the package. Now this is another COVID gift. If you've established that you've had an email conversation with them, you've got something that shows that you've emailed them and they emailed you back, or vice versa, and you put that in the package, then you can serve them by email. Some people are avoid you the best that they can, and this is a way of catching them. And this is for the RTDRS only. When we talk about get a little further, we're going to talk about after we get the order. That's under King's Bench rules, and that's a little different. We'll talk about that at that point. So then you fill out a declaration of service, and you file that with the RTDRS, so they know you're swearing that you've served it to them in a particular way, and that they got it. And the adjudicators will check with the tenant, and they say, did you receive it? And I've had some just say no. We've got the declaration that says we gave it to them in hand. Then we get some spittering and sputtering. There's a couple of things that can happen.
If someone is response on the door but they are not leaving, you cannot give it if he's more than 18 years old?
I'm sorry, say that again, please?
If someone responds on the door but they are not leaving, just came for a visit.
Okay, and they're under 18?
Above 18.
Okay, so somebody that comes and answers the door, they're not 18 and they don't live there.
Above 18.
Or over 18, but they don't live there. And no, you can't give it to them. You ask when they're going to be home. And what's happened in the past, and why they put that in there is that somebody will take it and then they'll throw it on the couch or whatever and cushion goes on top and then nobody sees it or whatever, and throw it in the garbage, and then he didn't get it.
So how we can trust them they are living there if they are not on the lease or there is no proof?
Yeah, it can be tough if there's no proof who's there, and we have that quite often where there's unregistered tenants in a unit that you know are there, but you can't prove that they're there. I've had where I've done inspections to see that, to come across that, and what I do is I'll count beds, and quite often they'll have everything being as neat as a pin because they know you're coming. You got to give them 24 hours notice, and everything neat as a pin. But there's a mattress on the floor next to the bed, and then you go in the next room or in the couch where there's a stack of pillows, 4 or 5 pillows, and you start counting, maybe a stack of blankets and stuff. So people are sleeping on the couch, and they're 2-bedroom unit. You got maybe 4 or 5 sleeping spots, and you can take pictures of that as you go. So you can use that as evidence. So there's different ways. You need to be a bit of a sleuth, a bit of a private eye, and think about what you see. When you're looking, you gotta, even if you go in to fix something, or repair a faucet or something, excuse me, you have your third eye working, and you look at what's wrong, what evidence there is, and you have your camera, your telephone with you. We're lucky nowadays we have telephones that have cameras, and take pictures of it. In contentious situations, I've often had my phone with the camera and in my shirt pocket. It works much better for guys than it does for girls, but and just videoing as I walk around. And there's no law saying that you can't do that. You not put it on the internet to advertise that they got an 80-inch TV. But that gives you evidence as well. So whatever you need to do to help make your case. Yes, sir.
Right. So when we go for inspection and the customer is at home, we are still allowed to take a video to take a proof.
Yes, of course. When you go and there's somebody at the there, yes, you have the right to. You don't want to video their stuff, their TV.
No.
You'll find, and I found out early on that tenants have much nicer stuff than I would ever think of buying because I don't have enough money to buy it. Nicer cars, nicer electronics, and you don't want to be taking pictures of that, no matter how much you like to have one of those. So then you attend a hearing, and this is your second presentation. So your first presentation is when you put together the package, you send it in, and it's saying you have to have focus and all that. So, excuse me. So currently the hearings are by teleconference. You submitted everything in advance. You may have added some extra information. You may have found out some extra evidence. You can do that. You can send it in up to 24 hours before the hearing. Whatever you serve to send to the court, you also have to serve to the other side. So whatever it is, and so you have all that in place, and you'll do your presentation to the court. It'll ask you some questions. How it goes is the RTS calls all the parties together. Usually the person who has submitted it is called first, and then in our case it'd be the landlord, and the tenants would be called, and then if there's any other people involved, maybe there's 2 or 3 tenants, and each one has to be called. Sometimes there's a representative on both sides, so you have quite an entourage on the phone. And then the adjudicator explains the process and the rules, who's to speak in turn, to be close your mouth and put it on mute if it's not your turn to talk. So then we had the claimant, that's usually us, goes first, and explain why you're there, highlights your evidence, and ask for desired income. So I always try to have it in the same format as I presented it written, but a lot shorter. So, for example, when I send in the lease, I send in the whole lease. But when I'm presenting, I'll only highlight the items in the lease that pertaining to what I want. So if it's strictly about money, I'll show that the rent's to be paid on the first of every month. In some leases, it shows 2 or 3 times that the rent's to be paid on time at the first of the month. And I'll highlight each one of those, and then I'll highlight that they've signed that. So they read it, and theoretically they read it and understood it. And then I go through, but just the items that pertain to what outcome. And then at the end, I say I want possession 5 days from service, meaning that after the end of the court, there's a court order made, and then that order has to be filed with the King's Bench and then served to the tenant. So 5 days from then would be from that point where it's served to the tenant, and that's when I want to have possession, and I'd say that clearly, and that I want a judgment for all the money owing up to the end of the month before, plus so much per day until the day of possession, and that sort of thing. So I make it very clear what we want. Yes, sir.
So by having it outlined there 3 times, maybe 5 times, that the rent is due at the beginning of the month, does that give you more clout to go into court because they signed the paper and they've seen it 5 times rather than just once?
Yes, yeah. So the more times it's highlighted, and the fact that they receive that document, they sign that document, and it says several times in there that they have to pay the rent, then it just goes to follow that they should have known. And I mean, other than common sense, which isn't very common. So then the respondent says their side, oh, I've been sick and I lost my job and whatever. And then we can have a rebuttal on each side, and a restatement of what you want. And then the adjudicator makes a decision and puts that decision into a court order. Yes, sir.
With regards to the evidence must be submitted in advance to all parties. So if it's a testimony from another tenant, should that still be given to the other person, because it's again privacy of the other person, right?
Yes, absolutely. It has to be. But what we do is we redact the name or anything that shows to the copy that goes to the tenant. So if it's an email from Mrs. Smith in 101, then we'll redact that just for the copy that goes to the tenant. The copy that goes to the adjudicator gets the full Monty.
Oh.
Yeah. Most tenants aren't so stupid that they couldn't figure that out, but you don't have the proof right in front of them. They can't say for sure that that's the person.
But the story, what you're writing on the email or sending to the court or the adjudicator, the people who are complaining, they if they read those documents, they can understand, and is that can make it more conflict to the neighbors. Like if we black out the name and the email address, but it's still a story we are writing, that could be understandable very easily.
Yeah, so what he's saying is that even though it's redacted, the tenant can figure out who it is, and there could be a confrontation. So yes, there is. There's a saw-off there as to, well, first off, is that evidence a good nail in the coffin, so to speak? And if it is, then the saw-off is, and the person that's writing it to you should realize that that they want this to stop as well. So they have to risk a little bit in order to get the reward. The same as we risk money and time and everything in order to get the reward of being landlords. I don't know if it pays off or not, but no, it's good. It's a great business. I like the business. So yeah, we've got makes a decision. There we go. I like this one. There's always a good excuse there. Yes, sir.
Just had a quick question. There's been 2 times in the past month when I filed a 14-day eviction notice with RDTRS. Had the hearing, the judge has granted vacant possession of the suite at a certain date. In both these situations, the respondent did not attend the hearing. I've already received the filed stamped copy back from the court. It's good, I have the date that we get possession on. And then 2 times in the past month, the respondent then filed another adjournment type of document in order to get a second hearing, using an excuse similar to my phone didn't work or the phone company cut me off.
I didn't get the
They couldn't attend because of their own negligence, and then they get a rehearing, which often can delay into the following month by the time. Is that normal? Is there anything that you can do to prevent that?
The only thing you can do to prevent that sort of thing. Okay, did everybody hear the question? Yeah. The only way you can circumvent that is to make darn sure that the guy got it. That's sort of putting it in hand is the best.
You got it though.
Yeah, and so if he got it and got it in good time, then the judge, it got in good time. Chances are that they won't allow that. So if you got proof of that, it's when it's a little muddy. That's when they'll grant a second hearing and to hear it over again. And again, it depends on the adjudicator. I believe there's 21 of them now, and they all think a little differently. And so it depends who's looking at that particular case at the time. But to answer your question, there's no foolproof way. The best way is to try and get it right in their hand and answer any question they've got. Excuse me. Whenever I used to do all the serving. I don't do it so much anymore. But I've always, when I served, I always tried to hang around just a minute or two and say, "Got any questions?" And the typical is, "What's this about?" And, well, you haven't paid your rent, and it's taking you to court. And so, if you've got any questions, my card's on there, and I always put my card stapled at the top. And I don't always get calls, but quite often I do. And they'll ask me, I don't understand this part or that part. And then when you get to the court, you can say, I had a conversation with this guy. He didn't show up. He hasn't showed up. I had a conversation with the guy, and we talked about it. And that's going to carry a lot of weight when the guy phones in or asks for a stay, and most likely then won't get it granted.
Okay.
Yes, sir.
When I've given eviction notices, I've go, and when I'm trying, I take somebody with me, I have them take a picture of me with the house and the address. And now there's proof I've been there, I go several times before I end up taking it to the door. And when I take the door, I show it, take the door with the address in it. So you include that all in your photographs when you're sending it in. You've proved you've tried hard.
Yeah, and I have process servers now that work for me, or with me, I should say, that's a better word. And we do that now, and the process servers will make a note of the time and everything that they were there. I mean, we've got it on the declaration, but also keep note. And we just had one recently where the fellow was trying to outsmart us. He took it off the door, and then he pasted back on the door, and then when he come to the court, he says, "No, I never got it. It's still, I think it's on the door." And so he had to try and do it again. And the process server noticed, she was making her notes, and you noticed the door open, and the fellow take it off the door. And so she had made a note of that. And then, so when the next time, we brought her in as a witness, and she stated right to the officer that this is what happened, under oath, of course. And so then now we got it off the ground. We're able to proceed with the hearing, and so that it's getting more. You have to have more and more evidence now. It's getting a higher bar. The bar's going up. You got to get more evidence. So it's always good to try and think ahead and how can I make sure I prove that that's going to happen. So big kudos to my process server for doing that. She's doing that.
Okay, so we can send an email every time and include the door as well. The email?
Oh, an email of the
Documents.
order.
Notice of hearing.
Oh yeah, you could send an email. That's not recognized as a good service.
That alternate
Yeah.
as well, like we can post on the door.
Yes.
Because in case if they say we didn't came home.
If you email, you need to have a method of proving. We have a program that lets us know every time that that party opens that email. Sorry, most mail programs have that, but you gotta go in and check that off for that particular email. We have one that just is for every email, and we get when it opens, we get a notification. It gets irritating when they open it 3 months later 5 times and the same thing, but that's part of it, of course. So yeah, so you got to be able to prove that they got it, and certainly I've had people tell me that, or tell court that they didn't get it and emailed it, but then we had the proof that they opened from the program. Yeah, we include that in it. Any other questions? Okay, so let's.
One more question.
Yes, sir.
Like, after the telephone hearing, if the judge didn't give the decision at the same time, and they said they will write us, both the parties,
Mhm.
and if the landlord is not agreed on that result has been given, we can reapply or
Yeah, you're talking about, and this is mostly in damage claims where the adjudicator reserves his decision and does it in writing, and they've got 30 days to do that. And so when they send that decision, you've got 30 days from the time they send that decision to appeal it. You usually appeal it. Oh, I'm sorry, people. Usually appeal it on a point of law. So the point of law meaning, did they use the right act? Did they understand that portion of the act? Did they apply it properly? That sort of thing. And not on the facts of the case. They can go to King's Bench and an attempt to go on the facts of the case, that usually doesn't go very far. The RTDRS is well recognized by the other courts, and very seldom is there a reversal or a change in what the RTDRS gives. I only know one personally, and that was based on, it was on a point of law. It was on whether when you've got 2 years from date of discovery to do an application. So the date of discovery, the adjudicator had a different date than what the tenant had, and when it went to King's Bench, then they decided that the tenant was actually right, and so then the case had to be heard. But that's the only one that I know of. That's on the point of law.
I had a situation, the customer is complaining about the noise, but we took an action for 14 days, eviction notice we gave, but it's still who complained against us, he's still claiming the money. Our leases end on November, and she agreed to move out on June. We agreed on it without lease break fees, but she is still claiming the money that she lost her work situation due to the noise. That's where she's claiming more money to the landlord. And the court didn't give the decision yet. They said they will give us some writing after the case.
Yeah, that's the RTDRS you're dealing with?
Yes.
Yeah, okay, so you had a hearing, it was about noise. And she complained that there was too much noise, she couldn't sleep or something. Work.
She lost
Okay.
time of work.
So went to the RTDRS, and so the hearing results have not been given yet.
It was 3 hearings. The first hearing.
3 hearings, okay.
Yeah, first hearing they say the lady wants to move out due to the noise, and without lease break fees, we accepted. And again, she reopened the file and she said that again you're receiving a noise, and I'm lost my hours for work because I'm working from home. So she again reopened the file, but she is claiming more money because she lost her hours
Okay,
of work.
so she claimed that the RTDRS, and she wanted to be let out of her lease, and they granted that.
We already
that correct?
accepted,
Yeah.
yes.
And then she's applied again for compensation for
Lost hours of work.
loss of work and sleep, I gather. And so what happened with that one?
So the judge didn't give the decision yet?
No decision, okay.
Yes.
And now she's opened the third one.
That's the third one.
Oh, that's the third one. Not missing one there. But anyway, so yeah, so you'll have to wait for the judge's decision. But the first one was she wanted to get out of the lease, so that would be the same as us evicting somebody from the landlord side. The second one is for damages, it's called a damage claim. And so I don't know how there was 2 in there, but yeah, you'll have to wait to see what the judge can. I don't know I couldn't say anything because I don't know the facts of that.
She was complaining about the noise. The top floor guy has drunk and fell down on the floors several times, and a lot of time the EMS has to come, so she gets disturbance. She cannot sleep.
Guy was causing above her, yeah.
Exactly.
And that's common in apartment buildings, very common.
But as a landlord, we took an action. We gave the 14 days eviction notice, and we are waiting for it. If they are unable to move out in 14 days, then we have to open a file again to RTDRS against that guy who is causing the problem. But still, we are taking an action. But if the customer is still complaining that landlord didn't do anything, that RTDRS would understand as well.
Okay, so so you took action against the fellow upstairs who was causing the noise,
Right.
and you evicted him.
Yes, we put the notice already 14 days.
Okay, and he left.
14 days is over, but she is still looking for a 1 week time. We already accepted, but the court is saying, you accepted for the request who is causing the problem. With the guy who is physically not living here, he said us, and there is no complaint at all, but it's still the RTDRS is taking the part of the tenant who reported the complaint against landlord.
Okay, so the fellow upstairs is left,
Physically left,
Physically
but not
left,
moved out
okay.
yet.
and the lady downstairs is still looking for compensation
Exactly.
for having been awake and
Yes.
missing work or whatever. Okay. Yeah, I've seen that many times. Usually those cases don't come out as a lot of money. Sometimes they do get some money if they can prove it. I've had where the tenant downstairs has recorded the noise from upstairs. It depends on how much money they spent on a mic. If they spend a lot of money on a mic and they got a very sensitive one, it can pick up all kinds of noises, which distorts things. So that's part of your defense. Then you can say, well, that's a very sensitive mic. It's skewing the information in the wrong direction. And so that's how you handle that. But once it's gone, once the adjudicator has heard everything and has reserved his decision, then you have to wait for that decision. It's nothing you can.
The landlord is not happy, we can re-appeal it.
Well, you can appeal it, yes. Yeah. Did he do it properly?
In a case like that, would he be able to put extra evidence in, saying the guy's moved out?
No, once the judge has closed the case, then it's over. No more evidence is heard. Anybody else? Yeah, here. So, file at the Court of King's Bench. So you've got the order now, and you file at the King's Bench, and so it becomes a legal document. And you serve that legal document to the tenant, and then the tenant has action to do. He has to leave, or he has to pay, or it's conditional order or unconditional order. And then after you've served it, then you've got to file an affidavit of service showing that you've served that document to the tenant, and how you did it. Then that gives you the ability to hire a bailiff if you need to. So if the tenant doesn't comply, so he's supposed to say, for example, it's a conditional order and you have to pay X number of dollars on the 15th of the month. Comes to the 16th, and there's no money, so you issue them a notice of default because they defaulted against that court order, and you hire a bailiff. The bailiff's going to require a copy of the court order and a copy of the affidavit of service, and because it's a conditional order, he's going to have a copy of the notice of default. So that gives him the right to then come, and he comes and removes the tenant. That's another thing. We've had lots of fun with some of those, but most of the time it's pretty basic. And then that's over as far as getting the tenant out. It removes the tenant, and the locks are changed at the same time. It keeps all the honest people out, and try to ensure that the people don't bring back hands. If they do, it's trespassing. Oh man, I might just shoot myself at the end there. Anyway, but they have belongings left inside, and so got to get those out. So there's my understanding it's 36 hours. They have to make now we're now into another act. We're into the Civil Enforcement Act, and 36 hours for them to make arrangements to get their stuff. And, that's all actually negotiable at that point. We find that most tenants at that point are compliant, they're defeated, they just wanna get their stuff and get out of there. And, they gotta arrange for some transportation, some trucks, some people, and pizza, or whatever they need. And you open up the doors and let them get their stuff out. And then it's over, except for the cleaning and the crying. That's where it goes. So then,
We can add those charges